Welcome to another Advice from Your Advocates. I'm Bob Manner. I'm a certified elder law attorney in Michigan. And today, our guest is attorney Marc Whitehead from Houston, Texas. He has a national practice. A good portion of what he does, it doesn't matter where you are. He can take cases from all over the country. Nice to see you, Marc.
Hi, how you doing?
I'm good. Marc and I have been friends for quite a while, several years at least, and have participated in a number of organizations together. And I thought it'd be great to bring Marc on and talk about disability claims. So I know one of the things that sets you apart and is very unique, because a lot of lawyers do disability claims, but I think many of them do Social Security disability. What's the difference between a Social Security disability claim and something that's related to private insurance?
Correct. Well, so all of us as workers, assuming we pay Social Security or what is known as FICA taxes out of your paycheck, which most of us do, you're buying into not only the Social Security retirement system, which is what you get when you hit your retirement age of 66 or whatever it may be, but you're also buying insurance through the government for disability. And that's what we commonly refer to as Social Security disability. Versus what I generally refer to as long-term disability insurance through some sort of private insurance company. Many people have access to that type of insurance through their employer's group employee benefits plan. A lot of people don't even realize they have that type of coverage. I mean, they realize that they have their 401k, and they have their health insurance and their dental and their vision and things of that. But part of that package is a disability insurance component. Again, you don't have a lot of choices in that. It's generally whatever your employer chooses to provide within that package. But a lot of people have disability insurance, private disability insurance through their employee benefits plan.
From your perspective, how are those different? So obviously from the individual's perspective, it's choice, whether if it's through the employer, you're kind of stuck with whatever the employer has provided. If you purchase your own independent, private insurance, you get a little bit more choice. But from your perspective as somebody that helps with getting those claims approved, is there significant differences between those two?
Yeah, so what we're talking about here is the difference between private insurance that your employer provides, what I'm going to call a group benefit package, versus you individually going out and shopping and buying your own individual disability insurance. So understand it's not an either or. You can stack these two types of coverages. For example, and for me personally, I have group disability coverage through my law firm, which is I'm employed by, but I also have purchased my own private individual policy, which stacks on top of that. There are a couple of reasons why you might consider purchasing your own private insurance on top of what your employer already provides. Number one, it may not cover all of your potential lost income should you become disabled. There probably is a limit. Secondly, there are a lot of ways that the insurance company through a group plan can deny claims, which are not available necessarily if you purchase your own private policy. So in other words, the enforceability of the claim is greater if you have your own private policy. It brings into a whole nother set of legal protections that are not available to you in a group disability insurance setting. And most people don't think about that. I think about it because this is what I do for a living, is I sue insurance companies to enforce them, to make them pay policies that they have sold. And when I look at a claim, if I have a group insurance policy that I'm trying to enforce, I know that I have a tougher claim to make than if I have a private policy. I have a much easier road to go down in terms of enforcing that policy, just based on how the law is structured. I don't want to get down too far of a rabbit hole of why legally they are different, but it is different.
Okay.
But also, if you're a high income earner, your group plan is probably not going to come anywhere near covering your entire potential lost income should you become disabled. So if you're a high wage earner, you definitely want to look at getting a supplemental private policy to make that up. Many people don't think about disability. They think about death. They think about life insurance. But, you're probably 10 times more likely to become disabled during your work life than you are to die during your work life. There could be, people don't think about it, but strokes, heart, neurological issues. There's a whole plethora of nasty little diseases out there that won't necessarily kill you, but they will disable you. So
it's funny, Mark, you and I often will probably be using that same language with our clients. I'm often talking about how people come to an estate planning lawyer to talk about death. I say, that's fine, we'll talk about that, but what's more important is what happens before your death, and making sure that you have process and procedure to maintain your wealth and during your lifetime, not just what happens after you die. Though most people, that's not their thought process when they come to see a lawyer. So I think you kind of a similar process is what you're saying, is something that you need to think about, not just life insurance for death, but what happens before you die.
Yeah, and I mean, there are statistics out there that say 1 in 5 Americans at some point during their work life will become disabled. Now, most of them won't become permanently disabled. It might just be temporarily, but a large percentage of the working population will become disabled at some point during their work life. And when I say work life, prior to age 65 or whatever that retirement age happens to be for you. But
a lot of people that are listening will probably have some understanding or know some folks that do have Social Security disability, but for anybody, if you know about that, it doesn't pay a whole heck of a lot, and certainly it's not enough to rely on that's going to kind of keep you anywhere similar to your current circumstances. So getting a independent policy might be a good idea. What are some of the companies, I know you're not going to list all of them, but what are some of the typical companies that offer these disability policies that are not provided, that are not part of a group plan?
That are not part of a group. Okay.
Yeah.
It's funny. There is a group of lawyers around the country that do this type of litigation, and we meet a lot and we talk a lot. And then one of the things that we ask each other is, for your own self, personally, what company do you use to buy your own disability coverage for? Because of course we know the companies that are notorious for denying claims, and then we know the good companies that will actually pay claims. And almost to a person, all of us carry Northwestern Mutual.
Okay, interesting.
I've only had 2 Northwestern Mutual cases in my entire career, and I've been doing this for 30 years. I could name other companies that I've litigated against hundreds and hundreds of times. So that is sort of the consensus amongst my peers, that we all carry Northwestern Mutual. Principal is another one that I think has a very good reputation, that I do not see a lot of cases that we're litigating against them, i.e. that means they're not denying many claims.
Right.
So that would be another one that I'm aware of that has a pretty good reputation. Beyond that, those are the only 2 I can think of, honestly.
Well, that's a really good tip. So as to the ones that you don't have to litigate against, that's a good tip for the listeners. So tell us about how this claim typically proceeds. When there is a claim, at what point would your office get involved? What would you recommend the point that you get involved? And walk us through what that process looks like, how long it usually takes. Is there actually a lawsuit that has to be involved? How does that look? Well,
hopefully no lawsuit. Hopefully they pay the claim. Let's say, so you have a policy, whether it's a group policy or an individual policy, you have to file a notice of claim. Let's say, I'll give you a hypothetical. Let's say an individual has a stroke, a stroke severe enough to disable them, but maybe not, certainly that they're still cognitive, they're still functional, and there's a hope that they might recover in the future. So you would file a notice of claim. Most policies have 2 parts to them. They have the initial short-term portion of the policy, which usually lasts about 6 months. And that portion of the policy generally will pay 100% of your lost income for that 6-month period. That's what's called the short-term disability portion of the policy. Hopefully that happens. Then the claim will convert over to the long-term portion of the policy, which has a different standard of disability, which is a little bit more difficult. And generally, the long-term portion of the policy will pay 60% of your lost income. So your benefits are going to go down after the initial short-term period. That's the way a typical policy is structured. And for the first 2 years of that long-term part of the claim, the standard of disability is that you cannot do your own occupation. In other words, go back and do the work that you were doing at the time of your disability. And then here comes the hard part. After 2 years, the standard becomes tougher. The standard then becomes you cannot do any gainful occupation.
Okay.
And frequently people are denied or kicked off their claim at that 2-year mark when the standard becomes more difficult. After I say 2 years, it's 2 years plus the 6 month of short-term disability. So really 2.5 years. But at that conversion, the carrier will look at the claimant very closely to make sure that they meet that tougher definition or not. So a lot of people come to us at that point. Now, claims could be denied at any point. Claims could be denied at the very outset. They could be denied at the conversion between short-term and long-term, or they could be denied at the conversion between own occupation and any gainful occupation, or anywhere down the road. That's when people would typically come to me when they are denied. You will get a denial letter. And within that denial letter, at the very last paragraph, there will be you have a right to appeal this. You have 180 days to do so. And that's the critical part, because that internal appeal, or what we would call an administrative appeal, is critical in how the case proceeds. A lot of people make the mistake that all I have to do is send a letter saying, please appeal. That is fatal in many cases, because what happens, the whole point of the administrative appeal is that is really the trial of your case. That is when you have to get all of your evidence in as to why the insurance company wrongfully denied you. Typically hire a vocational expert to do a report during that phase, because that is a critical piece of information that's very important. Generally, we get medical opinion evidence from the treating doctors. There could be a whole myriad of things to do in filing an appeal. Our appeals are fairly involved. They're usually like 50 pages long, plus a foot long of exhibits. But that's really the trial of your case.
Okay.
Because if you are denied at the administrative appeal level, then you have a right to file a lawsuit. But then during that lawsuit, typically the only evidence that the judge can consider, this is a lawsuit in federal court, which is a little bit more complicated. The only evidence the judge can consider is evidence that was submitted during the administrative appeal. You can't develop new evidence at the federal court level. And that is a big, big trap. It's a trap that even most lawyers don't know, because most lawyers don't handle this type of work.
Right.
So the long and the short of it is the claim could be denied at any point. And if it is denied, you need to go through the administrative appeals process and do it correctly. I do have clients who actually hire me to do the initial application.
Okay.
To make sure that the application is done correctly. That's not absolutely necessary. I think most people who have their cognitive skills can do that on their own. Of course, many people who are disabled are lacking cognitive skills. So again, the stroke example, that could affect their cognitive ability to actually do something, as straightforward as filing a proper claim, filling out the forms and so forth. So we do offer that service, but I feel that most people, as long as they have their cognitive abilities about them, can probably manage that on their own. But some people prefer to have us to take care of it. I typically am fairly honest with people. You don't do the applications. It's not a money maker for us in any sort of way. We do it as a courtesy, as a service, but we do have to charge for our time. And they don't absolutely need us, but some people just prefer to hire us and have us start from that point forward. But definitely when you get a denial letter, you need to consult with an attorney that actually knows something about this.
So just to recap, they can hire you actually at the beginning of the process, but most people wait until they get to denial. And that is a critical time period, because if you request the administrative hearing and don't have everything in, you could be barred from introducing new evidence at a later date. Is that accurate?
Right. Absolutely. Absolutely.
Okay. And so is there anything else that you can give tips as far as making sure that if there's anything to kind of set themselves up for success? So they're expecting to have a claim or they have a claim, and anything else, any tips as far as setting themselves up for success other than making sure that they get the lawyer involved as sort of as soon as there's a denial?
Right. So for disability insurance policies, there still is a pre-existing condition limitation within the policy. You know, pre-existing conditions have pretty much been eliminated in most health insurance, and a lot of people now know that. That's through the Affordable Health Care Act. They did not eliminate the pre-existing condition exclusion in disability policies. So if you have a situation where you have a relatively new policy that's been in effect less than 2 years, you want to think about that before you file your claim. You probably want to consult with an attorney beforehand, because you might run into a pre-existing condition exclusion. Now, if your policy's been in place continuously for much longer than 2 years, probably not an issue. But if it's a relatively new policy, and I use 2 years as kind of the cutoff, you have to be careful about that, because what happens is the insurance company will have a look back period, and they can go back and look in your past history. And if you complained about anything that is remotely similar to what your disabling condition is at the moment, they might be able to deny coverage based on a pre-existing condition. So that's the first thing. Be careful if you have a new policy. The second thing I would look at is that you want to get your doctor on board ahead of time. And unfortunately, some doctors do not like to get involved in any sort of claim of any sort. They don't want to get involved in any sort of what could potentially be litigation. I don't know why that is, but I've seen many doctors out there that are non-cooperative. So I would have a discussion with your doctor ahead of time saying, look, these are the problems I'm having. I don't think I can work. I want to make a disability claim. I will need you to give opinion evidence, or at a minimum fill out forms and help me with this process. And you want to get that doctor on board with you. If that doctor's not on board with you, you might want to consider changing doctors, because you are going to have a doctor back your claim. So these are things that I encourage people to kind of work out ahead of time. A lot of times people can plan for their disability claim, because most people are disabled because of chronic conditions that are just getting worse and worse and worse over time. Right? That's the vast majority of people out there. So in some sense, you can sort of plan your disability claim out. Now, there are other people, like, for example, my stroke example. If you just have a sudden stroke and boom, it just hits you out of the blue, that's a different situation. You really can't plan for that. You're just going to have to make your claim the best you can at that moment. But that's actually not typical. Most people have chronic conditions that just build over time, and they can see it coming.
Oh, well, those are very good tips. That's, I think, an important element to have. And again, don't be afraid to change your doctor sometimes. That might be an important part of the process.
We advise that a lot, and it is a difficult decision to make frequently. But sometimes you just have to do it if your doctor's just not going to be supportive.
And to think about it, Mark, nobody's immune from their own opinions and political opinions and ideas that they have about insurance and everything else. And so it's not even necessarily a judgment on their ability as a medical doctor, but if they're letting their personal opinions come in and influencing the way that they fill out the forms or give medical opinions, then maybe they're not the right doctor.
That's true.
So I heard you say earlier that we can double up with a group policy and one that's non-ERISA or not group policy that you bought on your own. Can you triple up? Can you get the individual policy, the group policy, and Social Security disability?
Good question. So actually, not only can you have to.
Okay.
So your disability insurance policy, whether it's your group policy or a privately purchased policy, will have a provision in it that you must file for Social Security disability. because Social Security disability is primary in the claims process. So what that means is they get to take an offset for what Social Security pays you. So, for example, if your disability policy would pay you $10,000 a month, and Social Security would come in and pay you $2,500 a month, because that is pretty much the limit for an individual, about $2,500 to $3,000, depending on where the COLA ends up this year. Mm-hmm. That's the most that Social Security would pay, regardless of what you were making. But under that scenario, what that means is the insurance company doesn't have to pay you the full $10,000. They only have to pay you the additional $7,500 to get up to the $10,000. So yes, it is actually a requirement of all insurance policies. And usually they put a time limit that you must file within 12 to 18 months. But that is absolutely a requirement of any long-term disability insurance policy, whether it's a group plan or whether it's privately purchased, is they want to see you filing for Social Security disability because they want to take the benefit of that. So it doesn't do you any good. It does your insurance company good, but you have to do it. Now, I will say this, if you are found disabled through your Social Security disability plan, it will eventually qualify you for Medicare benefits, regardless of age. So that is a big benefit, because if you are permanently disabled, at some point, you will no longer be covered by your employer's health insurance because you'll no longer be employed by them. So to be able to switch over to Medicare at any age, even if you're 40 or 50 years old, is very helpful, because what happens is you'll become uninsurable under any sort of group plan. Actually, once your COBRA runs out, ultimately is what's going to happen. So you want that Medicare benefit. That's a very important lifetime benefit.
Absolutely. And so now I suspect this is probably pretty rare, but is it possible that you could get denied Social Security disability and still get approved for the insurance-based disability?
Actually, that's not rare. That happens all the time. Understand that the long-term disability standard is you cannot be employable at your own occupation. The Social Security standard is you cannot be employed at any occupation, which is a much harder standard. The Social Security standard is much harder. So it is actually not unusual at all to see people who are granted on their long-term disability and denied on the Social Security claim. Now, eventually, in the long run, that creates problems, which is, again, why you want to have a lawyer come in and look at this. At our firm, we handle both the Social Security claim and the insurance claim, because they work in tandem so much that we have to have control over both to make it work. But in the short run means a couple of years, it's very conceivable that you could be on LTD benefits and your Social Security claim your appeal of your Social Security denial could be pending.
So that's actually really good to know. And so you, as I mentioned at the beginning, any of these, certainly insurance disability claims, doesn't matter where they are in the United States, you could represent them. We had an opportunity to talk recently with one of the other attorneys in your office, Brittany McDonald, and we have a podcast about veterans disability. And if you're curious, just go to any of the podcasts, wherever you got this podcast, go back into the archive, and you'll see the interview we did with Brittany McDonald from Marc, Whitehead and Associates to learn about veterans disability. I know both of those are national claims, and you can represent anybody in the United States. What about the Social Security disability? Are you also able to represent them regardless of where you are?
Yes. So all of these are federal administrative programs. They're not based on state law, so therefore we can handle cases anywhere in the country, as opposed to, say, if you had a state-based claim, such as a personal injury or something like that, you have to have a lawyer licensed in that particular state. The disability world is just totally different from what most people know, because it is strictly a federally based system. So it's unique in that regard. I kind of like it. In most cases, you don't have a right to a jury trial. So it's more of an administrative process that can be done on Zoom, just like we're doing it here. All the hearings are done this way. So we can, like I said, we can handle cases in any part of the country.
And, I'd like to mention this. I've known Mark for, I don't know, 7, 8, 9 years, something like that. And the thing about this is, and it's the same thing about my practice to a certain extent, that sure, you can find a lawyer that sort of dabbles in this, but Mark's unique in that he has built-in efficiencies in his office to be able to handle these insurance-related claims and the veterans-related claims. And so there's probably local attorneys that can do these claims. But what I like about Mark's office, what I appreciate about Mark's office is he's established a very efficient process. So I've referred him a number of cases and they never have to fly down to Houston. They don't have to fly up here, at least in any of the cases that I've referred, because they have that efficient process. And sometimes that's nicer not to have to go into a law office and worry about parking and all those types of things. So that's been my experience at your office, Mark, is that you guys do a really good job of making sure that there's a process in place. There's a lot of good communication. There's never a lot of back and forth where we're not sure what's going on with the case.
Yes, we try to be very efficient. We try to make it, we call it the easy button. We're the easy button law firm. You never have to get out of your house to come visit us. We do everything phone, Zoom. You don't have to go, with the exception of a Social Security claim, where you may have to attend a hearing. You never have to get out of your house. So again, most clients are disabled, and most clients, or at least frequently, have difficulty getting out. So again, that's why we have the easy button. We try to make it easy.
Well, so for anybody that's interested in learning more or getting more information, what's the best way to get a hold of your office, Mark?
Well, a couple of ways. So our phone number obviously is the best way, just to call us. Our number is 713-228-8888. That's 2 2s and a bunch of 8s. 713 area code. You can visit our website at disabilitydenials.com. That's denials with an S. You have to have the S on the end of it. So disabilitydenials.com is our website. Or you could email me directly. Now, the trick to that is my mother decided to afflict me with the wrong spelling of Mark. So I spell Mark. So it's Mark at markwhitehead.com, Mark with a C. And you can just email me directly. So
Marc, M-A-R-C at markwhitehead.com.
Yes.
Well, thanks, Mark. I appreciate it. It's good talking to you, and appreciate you coming on and sharing your knowledge here. I want to remind everybody that we do have a date for next year's Elder Law and Advocacy Boot Camp that is designed to provide continuing education credits for our social workers, people in the healthcare industry, case managers, and administrators. So I believe it's April 21st, which is a Friday. We're offering 5 continuing education credits, and you can sign up now or sponsor the event. So just another reminder on that. Thank you for joining us for Advice from Your Advocates, and hopefully you come back next time.